Good morning, everyone. I am Leonard French, your favorite copyright attorney. Let's see if we are live here before I continue. It looks like we are, but why are we black? There we go. Yay. Okay, hello everyone. So we have an update in the Sargon of Akkad v. Akilah Hughes case, or rather, I guess it's Hughes v. Benjamin. It's Akilah Hughes v. Carl Benjamin. And if you remember where we are in this, we got an epic ruling, like a seriously persuasive, basically precedential ruling, but not... Lawyers wouldn't call it precedential, but it is definitely an opinion that will be oft-cited in future fair use cases. So that was already epic. You can go see our previous videos on that. I don't have them queued up for you or anything. But then Sargon and his attorney, Wesley Mullen, moved for costs and attorney's fees in the 5 digits. I forget if it was... I forget exactly what it was, but I think it was around $50,000 or so, I think, in attorney's fees. And we did a video on that, which you guys found really popular. So this morning, when I saw that Akilah Hughes and her attorney had filed an opposition to that motion for attorney's fees and costs, which we'll see the details here in a second, I just decided, let's just put on a hat and go live and talk to you guys. So without further ado, here is the memorandum of law in support of plaintiff's opposition to defendant's motion for attorney's fees and costs. I would just shorten this to, this is the plaintiff's opposition to attorney's fees and costs. And it's rather short. It's only 7 pages here. So what's up, Brandon?
I was just going to say, I think we kind of forget sometimes that we started this case 2 years ago.
Yeah.
People might not even know exactly what happened with Sargon and Akilah. Do you want to give a short summary of what happened?
I'm pretty sure most of the audience is at least familiar that there was a dispute, but for the for the uninformed, Sargon had, back up one step. Akilah Hughes had been a supporter of Hillary Clinton, and she had made a video out of footage of the election night. So obviously before the election, many people were very sure that Hillary Clinton would win. I think even 538 was predicting a 95% chance or 92% chance or something that Hillary Clinton would win. And so Akilah was very excited and was taking video footage to then later on be edited into a video. And then of course the Democrats did not win, and so there was great disappointment on the Democrats' side, and Akilah also filmed some of that, and she put together a video called "We Thought She Would Win," and posted that to YouTube, to her channel, which was fairly popular at the time. I think a couple 100,000 subscribers or something. Along comes Carl Benjamin, aka Sargon of Akkad, and he is from the opposite political perspective, and he, instead of putting together a typical commentary video where you show a clip, make a comment, show a clip, make a comment, show a clip, make a comment, like H3H3 in the Matt Haas case, Sargon had simply put a title called SJW Levels of Awareness. SJW stands for Social Justice Warrior, and it is I expect it to be called a pejorative or a disrespectful term, although I've used the term myself. I don't find it to be that terrible of a term, but SJW Levels of Awareness. So a critical title, and Sargon's audience is typically the polar opposite political perspective from Akilah Hughes. And the difference was his video was simply her video, but reimagined, re-edited so that it showed sort of snippets of her getting excited about the win for Hillary Clinton and then disappointed at the loss. And that was the sum total of his transformation or repurposing or use of her copyrighted material. And that's what the judge said is a fair use, that by giving it a critical title to a critical audience, edited in a way that is critical. That's exactly the kind of thing we use fair use for. Whether you like it or not, whether you're upset that you got criticized or not, you can use someone's material to criticize them. This is what The Daily Show does. Regardless of whether we like The Daily Show's politics or not, the act of what they do, of pulling mainstream news footage and then mocking the heck out of it, is criticism, and that is exactly what fair use is meant to protect. So, without further ado, here is the memorandum of law in support of plaintiff's opposition to defendant's motion for attorney's fees and costs. So this is filed by her attorney, Kristen Grant, and only cites to 4 cases. These are some pretty important cases here. Campbell v. Cuff Rose Music is a copyright case. Fogarty v. Fantasy is a attorney's fees case. Kurt Sang v. John Wiley & Sons is another copyright case, and I don't exactly remember what National Football League v. Primetime 24 joint venture is. But this is fairly short, so let's see if they've packed a lot in or if we think they're just making kind of a Hail Mary argument. Plaintiff submits this memorandum of law in opposition to defendant's motion for attorney's fees and costs under 17 U.S.C. 505 and Federal Rule of Civil Procedure 54D. 17 U.S.C. 505 is an attorney's fees shifting provision. It says that the winner or prevailing party of a copyright lawsuit gets to ask the court for their fees and costs. But there is a key word in here that I would like to show you. And that key word here is may. The court, in its discretion, may allow for the recovery of full costs. So the court is not required to, or is not compelled by the law to grant the attorney's fees and costs. And then there's another part that they cite to Rule 54D. Unless a federal statute, these rules, or a court order provides otherwise, costs other than attorney's fees should be allowed to the prevailing party. But for attorney's fees, they need to be claimed by motion no less than 14 days after the entry of judgment, state the amount sought, specify the rule under which they are moving for the award. So that rule then is the 17 U.S.C. 505 rule. So back here, what do they have to say? And remember, this is Akilah Hughes, through her attorney, writing. Plaintiff is a popular internet personality and content creator who publishes video content on her YouTube channel, Akilah, obviously. On the night of the 2016 presidential election, plaintiff captured footage from Hillary Clinton's presidential watch party and used that footage to create an original video essay which incorporated snippets of the footage along with plaintiff's monologue. The resulting video was about 10 minutes, and it was original work called We Thought She Would Win, which they're going to call the original work. Defendant is a popular internet personality who publishes video content on his YouTube channel, Sargon of Akkad. And I believe that I've heard that Akkad Daily has now been demonetized by YouTube, so all my sympathies. We are definitely, we worry about those things too. Like one day you can just find all of your hard work just demonetized. That really sucks. Defendant created a 1 minute and 28-second video containing clips of the original work entitled SJW Levels of Awareness, the secondary work. Prior to commencing this lawsuit, plaintiff submitted a takedown notice to YouTube requesting removal of the secondary work. And what do we know about requesting takedown of a copyright? You have to do it through the DMCA, and you have to form a sincere, good faith belief that you are correct about your fair use analysis and that the defendant's copying is copyright infringement and not a fair use. Thereafter, plaintiff and defendant engaged in a number of email exchanges debating whether the creation of the secondary work was in fact a fair use. In response to plaintiff's takedown notice, YouTube disabled access to the secondary work. Defendant submitted a counter notification to YouTube claiming that the work is satire and intended for parody. And YouTube is just the middleman in there. As much as we love to rail against YouTube for the way they handle copyright, in order for YouTube to stay clear of its own copyright infringement suits from video creators, they have to comply with the DMCA. Now, that compliance means that a counter notification should get the video reinstated, and YouTube should be hands off in that process. Reinstate the video, notify the parties, and let them go at it in court. Upon the guidance of plaintiff's former counsel, who I believe was Michael Lee of Morrison and Lee, plaintiff commenced the present suit on August 25th, 2017. Now, why is that important? Why would Akilah Hughes' attorney sort of throw Morrison and Lee under the bus? Like, oh, we didn't start this. It was plaintiff's former counsel. Well, that's who represents plaintiff. Basically, when you have an attorney, that attorney is speaking for you, so it gets imputed to you in a sense, and you have Leibowitz levels of court hearings and disagreements when people start pointing the finger and saying, well, I wasn't the one who made the mistake, it was my attorney. Subsequent to an initial conference held on March 9th, 2018, where plaintiff was represented by new counsel, plaintiff submitted an initial settlement offer to defendant. No counter offer or attempts to resolve the matter were made by defendant. Instead, defendant filed a motion to dismiss, which was granted. That was the recent thing that we talked about in February. Defendant moved for an award of attorney's fees and costs. Plaintiff now submits its opposition to defendant's motion. And so there's a declaration here, and we're going to get to that in a moment here. There's actually several more documents. Section 505 of the Copyright Act grants the court discretion to award a prevailing party in a copyright infringement action reasonable attorney's fees and costs. Attorney's fees and costs should not be awarded as a matter of course, but rather the court must make a particularized case-by-case assessment, and that's Fogarty v. Fantasy. In making an attorney's fees determination, a number of non-exclusive factors should be considered. Of those factors, objective reasonableness is afforded substantial weight. So she's going to be arguing that she objectively was reasonable. I just cited a subjective standard, a sincere good faith belief for a 512F misrepresentation, 17 U.S.C. 512F, but she is using the objective reasonableness standard from Fogarty v. Fantasy, as that's the standard for attorney's fees and costs as well. However, the ultimate inquiry is whether such an award furthers the large objectives of the Copyright Act from Kurtzsang v. John Wiley and Sons. Those are the dummies books. Copyright for Dummies would be a John Wiley and Sons book, maybe. Argument: an award of attorney's fees and costs to defendant would not further the large objectives of copyright. While an attorney's fees, or rather, let me not skip this heading. Plaintiff's litigation conduct was reasonable, and her motives were in good faith. See, there we go. There's the good faith part. While an award of attorney's fees and costs adds to the reward for a victory, it also enhances the penalty for a defeat. In cases where a good faith claim has been brought and lost, an award of attorney's fees may repress the purpose of the Copyright Act, which is to promote the sciences and useful arts, is how the Constitution words it. This is especially true in the application of doctrines that are not clear-cut, but require a case-by-case analysis. That's correct. In these instances, it is difficult for a party to confidently know whether they will win or lose. Plaintiff commenced this action for copyright infringement with a good faith belief, there it is, that defendants' copying and uploading of wholesale reproductions of plaintiff's original content and adding a title was insufficient to amount to fair use. So they're trying to emphasize why they thought they would win. Plaintiff's motivations were clear. She believed that the secondary work was an infringement and fair use did not apply. This was her sole motivation for commencing this action. It is also clear that any heat of the moment banter, so I guess they're trying to sort of dissuade the court from considering the back and forth with Carl Benjamin, between plaintiff and defendant is irrelevant to her motivations for commencing this action and to the present motion before us. Plaintiff litigated her claims reasonably. Prior to filing defendant's motion to dismiss, plaintiff sought to settle this matter by providing defendant with an initial settlement offer while remaining open to settlement discussions. If you remember, she made like a $45,000 settlement offer, but she wanted the $45,000 from Sargon, not the opposite, not the other way around. It wasn't a settlement offer for her to pay or a settlement offer for the parties to just walk away. she wanted $45,000 from Sargon. Plaintiff made a reasonable attempt to resolve the litigation in its early stages. Defendant chose not to counter-offer or attempt to engage in any discussion whatsoever. Okay. And instead filed a motion to dismiss 10 days after receipt of plaintiff's initial settlement offer. There is no justification of the law, says the footnote, or fact for maintaining that any comment or criticism whatsoever on a work is presumptively fair. Whether a work is fair use requires a case-by-case analysis rather than bright-line rules. The statutory examples of permissible uses provide only general guidance. The 4 statutory factors are to be explored and weighed together in light of copyright's purpose in promoting the sciences and the arts. Defendant has been adequately compensated. Defendant raised money to fund the defense of his lawsuit via a GoFundMe campaign, and we'll see that in a moment. Defendant raised approximately $122,000 US dollars or 95,000 pounds. Defendant incurred attorney's fees and costs totaling is $33,000 plus 5,000 USD, so $38,500 for the present motion. After deducting defendant's attorney's fees and costs, defendant earned a surplus of approximately $83,365. I don't know if you can say that he earned it. I mean, on one hand, certainly I'm not saying that he didn't get a bunch of donations from a obviously loyal fan base, but what I'm saying is that is Akilah Hughes' attorney being a little disingenuous, saying that those were earnings as opposed to, say, gifts or just a symbol of his popularity? I'm not sure, but they're saying that defendant has already been adequately compensated. An award of attorney's fees and costs to defendant would be unjust, she says. An award of attorney's fees would not increase the deterrent effect. That is one of the purposes of awarding attorney's fees and costs. There is no precise rule or formula for making attorney's fees determinations, but instead, equitable discretion should be exercised, and courts must view all circumstances in a case on their own terms in light of copyright's goals. An award of attorney's fees is justified in particular circumstances to advance considerations of compensation and deterrence. This is not one of those particular circumstances. Considerations of deterrence may support an award of attorney's fees to the prevailing party where none of the other relevant factors justify an award. There we go. That's what the National Football League v. Primetime 24 case is about. As evidenced above, the other relevant factors do not support an award of attorney's fees. The plaintiff's motivations were in good faith, and she litigated the case reasonably. Notwithstanding the above, the defendant's success and his GoFundMe earnings have furthered the purpose of the Copyright Act, and an award of attorney's fees and costs would not add to the existing deterrent effect. Plaintiff has faced widespread public criticism as a result of losing this lawsuit, and they're going to refer to that in Exhibit B. We'll take a look at that in a moment. Thus, an award of attorney's fees will only be additional unjust punishment for her good faith attempt to enforce her rights. Plaintiff commenced this action in good faith and litigated her claims reasonably, attempted to resolve the lawsuits in its early stages, even if we believe that an attempt to reasonably resolve the lawsuit for $45,000 in Akilah Hughes' favor. I don't know if I think that's a reasonable attempt to resolve it. Thank you, Matt, for the $50 super chat. This channel is awesome. Keep up the good work. Thank you very much. I really appreciate that. Further, defendant has already been adequately compensated, and an additional award would add no further deterrent effect. As such, plaintiff respectfully requests the court exercise its discretion and deny defendant's motion for an attorney's fees award. All right, well, that's interesting enough, but then let's take a look at what she has to say. We have a declaration from her. What is a declaration? Well, this is what a declaration looks like, and what it is like an affidavit under oath. If you've ever had to go swear something before a notary or swear something in court, that's an affirmation or oath. And then when you put it in writing and you write it out like this, that's an affidavit or declaration, and that can be made under oath in front of a notary. But in the federal rules and in the federal law, you can instead make a declaration under penalty of perjury, which is supposed to be the same thing. So here she says under, literally, this is the law. If you go look up 28 USC 1746. Heck, this is a short stream. Why don't we do that real quick? 28 USC 1746 is allows for unsworn declarations under penalty of perjury, and you just have to follow this procedure. If you're in the United States, you declare under the laws of if executed without. If you're outside the United States, then you say under the laws of the United States of America under penalty of perjury. And if you're in the United States, then you just declare under penalty of perjury. So it's really simple. So she is over 18, of sound mind, and otherwise competent to make this declaration. The evidence set out in the foregoing declaration is based on personal knowledge. Thank you, Annette Erdseek. Thank you very much for the Australian 10. Thanks for the great content from Australia. I am a plaintiff, she says, in this action, and I submit this declaration in support of my opposition for attorney's fees and costs. Attached is Exhibit A, which is a true and correct copy of snippets of the email exchanges between defendant and I, requesting YouTube's removal of the secondary work. Attached as Exhibit B is a copy of a screenshot showing comments on my YouTube account from supporters of defendant in this lawsuit. That's it. I declare under penalty of perjury the foregoing is true and correct, and that's her signature. And so what is she talking about here? She's talking about this Exhibit A. This is emails. I've redacted the email address out because I don't really want to further any exchange between the parties if she already feels like she's being harassed. Hi, Akilah. So this is Carl Benjamin writing. Hi, Akilah. Is there any reason you've leveled a false copyright strike against me? Do you understand that under fair use, I can use copyright work in a transformative manner for parody or satire? I'll naturally be contesting your claim, and I will win. And he was right about that. I've been through this process with YouTube many times now, so I'm sending you this email as a polite way of seeing if we can't discuss the issues. And she says, satire or parody requires commentary on the original work. Putting SJW in the title is not fair use or commentary. YouTube won't be reinstating it. Well, there's a couple things wrong with that. First, we know that she was wrong about the fair use. Putting SJW in the title and making this video turned out to be a fair use. But then she says this thing, YouTube won't be reinstating it. That's a complete misunderstanding of the counter notification procedure. If she takes something of his down using the DMCA and then he issues a proper counter notice, which I mean proper as a procedure, then you can't do anything about that, YouTube. YouTube has to take down the thing in the original. Sorry, I'm getting a phone call from my mother. Let me just make sure that I clear that. So if you get a takedown notice under the DMCA, the proper procedure is for YouTube to take the information down, notify the content owner whose video was taken down, and then the counter notification requires YouTube to put it back up. So YouTube would be reinstating it even if she's right about it being not a fair use. So then he goes on, hi, Akilah, I'm sorry to tell you this, but editing is a transformative process and can indeed be used for satire parody. Wow, I'm really impressed. The rest of us really weren't this confident about his work being a transformative fair use. It certainly seemed like a possibility, but I wasn't 100% confident. I'd recommend speaking to Jonathan McIntosh to get more information. You can contact him at this Twitter account. It'll help you understand the nuance of the issue. It's simply not true that a 2-minute remix of your video constitutes a direct replication of copyrighted material. YouTube will reinstate it as I am within the bounds of U.S. law. I'm happy you've reported me, as this will help hasten the process. She then... he says, you are a comedian. Can you honestly not see how my video was satirical? And then she writes, look at the comments on your video. No one thinks it's satire. There was no commentary. If you think there is, please tell me what the commentary is. There's nothing here. And he writes, the comments on that video were satirical themselves in total recognition of the satirical nature of the video. There are no comments calling you these nasty words or anything of the like, at least not that I saw. The YouTube comment filter automatically screens such things, and if it doesn't, I remove them personally. I mean, it sounds, I hear a lot of complaints about Sargon, especially whenever we do one of these videos, but I wish people would at least go and look at the content he creates to see whether it's true that he writes nasty things. He is here in this email defending himself by saying he removes comments that are particularly nasty or discriminatory, etc. And he seems to understand what he's doing is allowed under the law. Let's continue here. Then here are the comments on her recent video. This is Exhibit B from her declaration. And I'm not necessarily going to read all of these out, but she's trying to say that these comments indicate something. Let's see, what was it? Comments left on my YouTube account from supporters. And I guess this is an attempt to make him look bad or something. I'm not entirely sure. But these are some things that people have said on her YouTube channel, and she can remove anything that is over the line. Mockery is legal. So then, almost at the end here, here's a declaration, just like her declaration. Here's a declaration of her attorney, which says that she's the plaintiff and received a telephone call from Wesley Mullen, Sargon's attorney, with an initial offer of $46,000 to settle the lawsuit. Counsel confirmed that defendant will not accept this offer and will not provide a counteroffer. So they didn't offer to provide a counteroffer or try to settle the lawsuit otherwise after the $46,000 thing. So why would that be? Why wouldn't Akilah Hughes lower her demand or just agree to walk away or something? I think she was quite sure she was going to win. Ironically, very much like her original work, we thought she would win. Anyway, attached here too is Exhibit A is a correct webpage printout showing the GoFundMe campaign I declare under penalty of perjury. And here is the GoFundMe campaign as Exhibit A. So it's just confirming that he was able to raise money, and so he doesn't need to be compensated, she's trying to say, and instead any attorney's fees award should simply be for a deterrent effect, and that we don't need to do a deterrent effect here because the parties didn't misbehave. Akilah Hughes thought she would win, and thought that she would win as a good faith, sincere belief on reasonable, objective grounds that there hadn't been a case like this before. I think there had been cases, but maybe not this particular kind of popularity and this particular kind of clarity. On the other hand, it's entirely possible that she was just completely wrong and now has to pay for all of his costs and fees. Now I have a little bit of a treat for you. I also have a treat here for my dog. So let's see if we can get Nico up on my lap here as a little bit of a reward for putting up with me. Go over to OBS so I can zoom out here. Hey, you want to come up? You want to come up? There you go. There you go. Let's put the microphone down a little bit here so we can see the dog. Do we have a webcam here? Can I use the webcam? Yeah, there we go. Let's point the webcam down at you. There we go. There's the pupper. This is my good pupper. Your donations pay for more dog grunts and more dog treats. Ilsa, would you like a treat too? Can you get in here? You got one. Good. Yep. So these are the puppers that keep me sane when I'm home. So how much will she have to pay? You just stole the treat off the desk. Good boy. We don't know. The judge might pare that attorney's fees award down. You saw from the Christopher Hook case a couple days ago, it might have even been yesterday, that a Judge Otis Wright really gave it a haircut, took off 30%, adjusted their attorney's fees rate, like the $420, adjusted their $500 an hour rate down to $420 an hour. Yeah, there's more puppy grunts. And also basically limited their $40-some thousand award down to a $17,000 award, which is still a lot for an outburst for a series of outbursts from Christopher Hook. Are you enjoying your ear rubs? Are you enjoying your ear rubs, huh? Yeah. Yep. We get all the happy Nico grunts. All right, one more. You can have one too, Ilsa. Anyway, so that's really all that there is to that. The judge will now consider the parties' arguments and decide whether to award the full requested attorney's fees or pare it down a bit or deny it completely. I don't know exactly where it's going to go because they're really Kristen Grant, attorney Kristen Grant, Akilah Hughes' attorney, is not wrong that having an objective good faith belief or sincerely held good faith belief that you're doing the right thing in your lawsuit, having that does affect whether you get your attorney's fees awarded. So the judge very well could just deny the attorney's fees award, and we'll have to wait and see. The judge will now take some time to consider it. I would expect it to be a week or two at the most, but attorneys, or rather judges, can take really as much time as they need. Let me give a thank you to our supporters here. Masticator Deluxe, that's a good old doggo, good old bark bark. Thank you for the $2. O Strider, my dad is an attorney, and Georgia, I showed him a few of your vids. I'm planning to go back to school and will pursue law as well. Thank you for the $5, O Strider. And I believe our $50 supporter deserves a little bit more recognition there as well. Thank you again, Matt, and for the $50 support, and Annette for the $10 Australian. Really, really appreciate that. On that note, that's all I have for you today, as the lockpicking lawyer says. And I will end up seeing you in the next videos that drop. I think tomorrow, let's see, tomorrow we are doing... If I could, nope, Discord is just simply not going to respond to me right now, of course. Tomorrow, I think, is another Leibowitz case. So if you like if you like to see attorneys get smacked down, check out our next video on attorney Richard Leibowitz, who's a copyright troll who has gotten his butt handed to him a whole bunch of times, and is now doing another one where he filed a lawsuit under the wrong copyright registration and then isn't exactly being forthcoming with trying to fix it. So this is a community-supported legal education channel. We thank you for your support on patreon.com/ljfrench and sponsus.com/law. Thank you to our $50 plus supporters in the month of March. Thank you to Wes Delj, Aspernari, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Steven, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, and heads up, Mullen PC, that's Wesley Mullen, that's Sargon's attorney, Jared Bales, and Anders Thorenfeldt. Thank you very much for your support in the month of March. We really appreciate it. We also have $5 plus supporters who go in the description of the videos, and we have other supporters who are not recognized by name, but we do appreciate every dollar that you donate. So I'm Leonard French, your favorite copyright attorney. I'm going to go take this phone call from my mother and go spend time with my dogs. See you all later. Love you all. Have a good one. Bye.